I call the honourable member David Cleandon.
Tēnā koe, Mr. Speaker.
Tēnā koe.
Ki mihi nui kia koutou. Mr. Speaker, I'm pleased to make a few comments about this bill as it proceeds through the House in a reasonably brisk fashion, I'd have to say, which is appropriate given that the content of it is important. It does seek to plug a reasonably large and gaping hole in our regulatory and oversight legislation. So this bill sets out, of course, to improve the level of financial oversight and prudential regulation of the rather inelegantly named non-bank deposit takers, including obviously everything from credit unions through building societies through to the many finance companies, some of which have fallen into considerable disrepute in the last few years. Of course, the breadth of the spectrum of organisations that this bill set out to cover was one of the initial barriers, one of the initial concerns, and I know this was reflected in the consideration of the Select Committee. Clearly, organisations like credit unions are honourable unions. They have a very long history. To my knowledge, we've never had a failure of a credit union, and in fact, contemporary credit unions agree amongst themselves that none of them will be allowed to fail by their peers in a way that would disadvantage their investors. And I think that's a very solid and good approach. Similarly, many of the building societies have a good long history, and so the key was to punish the wrongdoers, if you like, to put barriers in place to the sort of unregulated, unconstrained, incompetent and often illegal activities that we saw that was rife in recent years, but not to impose too much compliance cost or regulation inappropriately on some of these smaller and more honourable institutions. And I'd have to say that the outcome of this bill does seem to be that quite difficult balance has been struck, and I'd have to compliment the members of the Select Committee who seem to have navigated that difficulty very well. Ideally, we want sufficient regulation, we want to minimise compliance, but also to ensure the integrity of these organisations, because the point has been made by a couple of speakers already that we do need to give people places to invest their money other than in more bricks and mortar. We need to rebuild confidence that people can invest their money in productive enterprise using mechanisms like these perhaps a new generation of finance companies, and that's to the extent that this House can increase that level of public confidence based on genuine integrity, reliability, well, that clearly will be a good thing. We know, of course, that the situation that occurred in the 90s and indeed in the early 2000s was to a large extent driven by the excessive deregulation, the madness of deregulation that was upon us in the 1980s and through into the 1990s. We hope the lesson has been learned. We fear it hasn't, that sufficient regulation is necessary to the operation of a genuinely free and fair market. Excessive deregulation counts against that. Hopefully that lesson has been learned, and this bill goes some way to putting that in practice, the lessons of that time. There's a great deal about integrity in this bill. In the Greens, we still consider that in much of our legislation around business, around financial practice, that there are still too many legal mechanisms allowing individuals to escape responsibility for their actions. We have no sense that all business failures are the result of incompetence or indeed dishonesty. Clearly, things do go wrong, businesses fail, companies can fail. But we do feel that too often there are too many means by which people can legally avoid individual responsibility. And over time we'd like to see further amendments in the broader picture to ensure that where excessive risk is evident, where individuals have not acted responsibly or with integrity, that there should be much more personal liability. Partly because we think that would engender a much more thoughtful approach to doing business, and there is an absolute responsibility. If people choose to be reckless with their own money, their own resource, good luck to them. But when people are managing on behalf of other people, then that is at the point at which the appropriate level of risk has to be ascertained, and that liability must be sheeted home to those who have acted irresponsibly or without due regard for the well-being of the investors. Sir, I've made the point already that it's quite a complex piece of legislation. There are many stakeholders in this, and there are many relationships between this legislation, this bill, and multiple other pieces of legislation, each of them in their own right quite complex. I claim no expertise or experience in commercial law, but even for the reasonably informed layperson, it's easy to see that a bill like this could have a lot of unintended consequences. There could be fishhooks in it that would lead to further difficulties down the track. And again, I'd have to say I think the Select Committee's probably done a pretty fair job of navigating through that. The idea of delaying the commencement date was, I understand, an acknowledgement that there could otherwise be unintended or consequences that were not preferred by the committee and indeed the affected parties in this bill. So all in all, it does seem to be a useful piece of work has been done here. It by no means gets us to the end in terms of ensuring people that their investments will be secured, will be responsibly managed, will be surrounded by integrity and a reasonable degree of individual responsibility and liability when things go wrong. But it is a good step in the right direction, and for those reasons the Greens will be happy to continue to support this bill. Kia ora.